Welcome to the latest episode of Call to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are, as always, speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, and today I'm delighted to be here to discuss her new article, Dollar Hegemony as International Lawmaking Power, published in the Chinese Journal of International Law, with my friend and co-host Ntina Tzouvala, Associate Professor at UNSW Law and Justice. But before we begin, traditional first question, noting it's almost lunchtime on a Monday. Ntina, what's your drink?
Yes, as you said, Doug, it is not a time for very adventurous beverages. I am having a peppermint tea with half a spoonful of honey, and I'm drinking it out of a mug. People cannot see it, but it is a delightful mug with flamingos.
Pink flamingos. So there's a revolution in Eastern Europe at the moment, which is the Pink Flamingo Revolution, as I understand, protesting against a Trump-based plan to create a holiday resort on an island full of endangered flamingos. So, and we'll come to interesting elements of geopolitical power and finance in a moment. I went in search of peppermint tea, but found only my long-time listeners may recall a sampler box of Korean teas I had quite some time ago, I think in season 1. I've rediscovered it and I'm having mulberry leaf tea, which I've never had before, but which is pleasant. Okay, now, Ntina, we normally start our podcast episodes with a bit of background. We've discussed your career path before, but I thought it'd be interesting before we get into the detail of it. Can you talk a bit about the process of writing this article? What was the inspiration or spark for it? And, did you write it alone in a garret surrounded by books, or did you have to workshop it half a dozen times? And finally, why publish in the Chinese Journal of International Law? Why was that a good fit for this paper? So, idea, process, publication venue. What are your thoughts?
Oh, thank you. That's so helpful as a question. I started thinking about the dollar and international law actually when I read an article that Nico Krish published in EJO a few years ago, which was about jurisdiction. Right, which, as we will get to it, is a big part of this story. He wasn't particularly concerned about the dollar, but at some point he was talking about the FIFA corruption scandal and the fact that quite a few of the people who were involved in the corruption were actually indicted and put to trial in the US, even though, they were not US citizens. The football matches that were being set up, most of them were not US football matches, soccer, whatever our listeners understand as the right word. It's football, in my view. The only link was that the corruption had happened through the electronic transfer of US dollars, right? And I'm interested in political economy, but that was quite remarkable as a link. The tenuousness was pretty interesting. And that got me thinking and reading, and I realized that there is truly a wealth of information and things to think about when it comes to the dollar and international law. So that's the first. I am not the sort of person who writes things, sitting alone in my office. I tend to first, before I write anything, I tend to present things first and sense check it multiple times before I actually write it. And that takes me also to your third question. One of the first times I presented it was in the ALCO China annual conference. ALCO is the Asian African Legal Consultative Organization, which is basically a legal law-related international organization that came out of the Bandung Conference in 1955 and has existed non-stop since then. It has known worse and better moments. And for the last decade or so, every summer, China organizes what is essentially a legal diplomatic capacity building meeting, and I was invited to present in one of those, and that was one of the first times, if not the first time. I think it was possibly the first time I presented on it. And before I wrote it up, I presented it in different versions and in different lengths. I would say at least 4 or 5 times. So I really present things a lot before publishing them. Why did I submit it to the Chinese journal? Well, I have to say there is a combination of noble and less than noble motivations. The less than noble was I reckon they would like it. I reckon obviously that it would,
Always a good reason.
yeah, because I thought it would get, obviously, because it critiques and criticizes both the US and its use of its monetary powers. So I thought that a Chinese audience would be receptive to that argument, perhaps more than, let's say, a US Journal of International Law. So that was one reason. But in slightly more intellectually defensible when it comes to slightly more intellectually defensible reasons. China obviously has been a skeptic when it comes to dollar hegemony, or at least has been a skeptic when it comes to particular aspects of dollar hegemony. So I was very interested in having a Chinese audience, as well as, of course, a Western audience read it, because I think, and especially in 2026, the economic dangers and even the security dangers of dollar hegemony are clear, but I think there needs to be an understanding also of the legal privileges or the lawmaking privileges that this economic fact affords to the US. So it was a combination of wanting to get it published, but also ensuring that it will get a broad audience and a broad audience across different jurisdictions and across, different geopolitical formations, to put it like this.
No, thank you. And I think it's something we should probably explore on the pod more, the kind of strategic decisions people make around publishing. Because I think a lot of junior scholars are just like, oh, well, I'll just submit to the top journals in my field or, whatever I've heard of. And actually one of the things you get over time is a bit more of a sense of what forums are most receptive to the type of scholarship you do. But in any case, so we'll get on to, we've already thrown out a lot of ideas and we'll come back to definitions, but you've already sort of signaled a link here between the interaction of international political economy and international relations and international law. But boiling it right down, as I understand it, your central claim is that dollar hegemony is not simply an economic or geopolitical phenomenon, but a form of international lawmaking power. What does that mean in the simplest terms?
Right. To explain really quickly what I mean by dollar hegemony is simply the fact that the US dollar is used not simply as a currency within the United States, it is used as an international currency, and indeed as an international currency with no real competitor at the time being. No other currency has the magnitude and breadth of international uses that the dollar does. Simply speaking, when Australia sells iron ore to China, so an Australian business sells iron ore to a Chinese business, they don't do this transaction neither in Australian dollars nor in renminbi. They do this transaction in US dollars, right? So that is what it means to say that it is used as an international currency, even when none of the actors involved in an economic activity are US natural or legal persons. Very, very often, this economic transaction is denominated and it's carried out in US dollars. So that's what dollar hegemony is.
Right. So essentially, if you're going to engage in an international transaction, an international commercial transaction, you're almost forced to use the US dollar.
Exactly, you have to have dollars, right? Especially, for example, if you want to buy particular goods such as oil. And we can discuss how that came to be. That did not come to be in a natural way, right? Or in a spontaneous, let's say, way, right? So even if you don't want to use dollars, you kind of have to, and that creates a spiral, right? Because you might not want to sell in dollars, but you need dollars to buy, let's say, oil, which means you have to sell in dollars, even if your preference wouldn't be that, because otherwise, unless you're the US, you have no other way of getting dollars. Or if as a state, and that applies especially to developing states, you want to have sizable reserves because, let's say, your economy, in particular, your currency is a little bit unstable, and you have to have money in the corner to stabilize it if need be, which basically means sell that money that you have and buy your own currency to stabilize its value. Usually, not exclusively, but usually the money you have to have is US dollars. So that's the situation, right? When I say it operates as a form of lawmaking power, I mean the following thing. Dollar hegemony gives the United States unparalleled and unmatched opportunities to engage in the sort of activities that create international law. It gives us opportunities, let's say, in custom, to engage in state practice and express opinio juris, and it gives it unmatched opportunities to interpret particular treaties, right? And therefore, they just do so much more and in such more influential context, and we can get to that, than any other state, right? And therefore, they can create international law, at least in certain areas, not in all areas, much more than anyone else, even if formalist accounts of how law is created doesn't fully capture that. That's the essence of my argument.
Great. Well, I think that covers the preliminary matters I wanted to tick off. But yeah, so I think hopefully even at this stage, before we get into the detail of the argument, the listeners can intuit, well, if you control all of these financial flows and transactions and how that's administered and adjudicated, that means at the least, even on a more formalist account, you're just generating an awful lot of practice. And we can go into how that becomes particularly influential. So your argument proceeds in three stages. Could you walk us through that structure at a high level?
Yes, I love a three-fold argument. Like it's a habit of thought. It's not a good thing. People shouldn't do it.
I don't know. There's something to be said for methodology, case study one, case study two.
Yes, fair enough. And then a sort of like theoretical-ish conclusion. So I have a methodology that basically I try to defend bringing together of political economy and lawmaking it. And I'm trying to defend it in regards to two alternatives. One alternative that I would call formalism in international law, and another critical alternative that would be the law and political economy approach, right? So I'm trying to say, look, if we take the formalist approach, that by the way, I think the formalist approach has a lot going for it, especially in this political moment. I'm happy to explain what I mean by this. The argument would be, look, at the end of the day, it doesn't matter if the US creates a lot of state practice, because the state practice and opinio juris of one state cannot create customary international law, right? And I think when I say it has a lot going for it, there is something in this moment in insisting in sovereign equality, right? And saying you cannot create custom by yourself. There is something about this, but I will explain in a moment why I'm a bit uncomfortable. And I'm also trying to defend it towards the law and political economy intuition that instead of saying what I am, which is economic power creates legal power, it tends to say the opposite, or it tends to emphasize, let's say, the opposite, right? It tends to say law constitutes political economy,
Mm.
and therefore
Mhm.
creates economic power and disempowerment, right? And again, I think there is a lot going for this argument. I don't
Sorry,
think
if I can just interrupt to crystallize that a bit for the non-specialist. So one of the claims there is that law creates markets. So
100%,
for
yes.
example, if we think of carbon offset schemes, you don't. There wasn't previously a market in trading. I don't know, ownerships of trees or something that is notionally meant to offset the carbon you emit when flying. But this is now something you can buy as an add-on to your airline ticket and hopefully feel better about yourself, and maybe if it's not horribly greenwashed, actually do something useful for the planet. But nonetheless, that market didn't exist prior to law. Law has created a tradable market in a thing that all carbon credits and offsets. We are an overpolluting industry. We will buy carbon offsets from an underpolluting industry, and there will be a sort of transfer of wealth in a way that's ultimately meant to overall reduce pollution. These are markets that have been created by law. So it's taking that intuition and applying it more generally. Am I right?
100%. And like at the very basic level, LP scholars would say the very like markets could not exist with some minimum rules, legal rules of contract and property, right? That having at the very basic level contract and property creates markets and can make markets more or less just, more or less efficient, whatever. Like how much weight we put in a contract in our contract law on, let's say, autonomy versus equality can create markets in different ways, right? Because it will distribute powers and rights and obligations differently. And therefore, what you can do in these markets will be different, right? Whether you can contract and property tell you whether you can create a market in human beings, right? Slavery,
Right, right.
transatlantic slave
But,
trade.
but, but also for legal scholars, this is an attractive form of argument because it puts us in the driver's seat.
Exactly. And that makes me a little bit worried when lawyers are in the driver's seat. So here is my concern, which is a legal realist concern about the former argument, the formalist argument, right? That says, well, at the end of the day, it doesn't matter what the US says and does. It's just one country out of 190 something. It doesn't create customary international law simply because of the dollar. I find a lot of inspiration in legal realism, and I can explain later what I mean by this, but I really like the aphorism that says, law is nothing fancier than a series of predictions of what courts will do in practice. I would say in international law, it wouldn't be just courts, but law is simply, it's not a set of abstract rules. Law exists as a social phenomenon, right? And for example, there is some estimations that say that 50%, 50, of all sovereign, or more than 50% of all sovereign immunity cases anywhere in the world are not just heard in the US, they are heard in New York courts, right? 50% of all cases. For
That
this,
is staggering and
yes,
helps answer one of my later questions, which is why is one of your case studies
yes.
sovereign immunity?
Because it makes it so obvious that there's something going on, is the answer. And the reason for that is if you want to hold dollars, you don't have to hold them in a US bank, but it can really sometimes be helpful and easier if you do, right? Which means you're holding it ultimately in a bank that is somewhere in lower Manhattan, which means New York courts will have jurisdiction over your disputes about these dollars, right? Which means if you want to bring a case against the state and you don't simply want a symbolic victory, you also want to execute against them, you want to get some assets, you want to do it where that state has liquid assets, And I'm going to tell you that statistically speaking, this state is going to have liquid assets in lower Manhattan, because it's going to hold its dollars in, for example, with the Federal Reserve or with private New York banks, which means your dispute in the first instance will be heard in front of New York courts. So
Right.
my point, sorry,
Sorry,
yes.
can I try and bring it back to my understanding of your argument? So your beef with formalism, if I can kind of put it that way, is that it overestimates the level of determinacy and certainty about what counts as rules at the international level. In that the materials we've got to work with as international lawyers are just fundamentally more contestable. Now, that's not to say that domestic law is perfect and doesn't have a heavy degree of indeterminacy and everything else. But as I understand it, your core point is that, or what you really want to examine is the social forms of power that mean others treat your claims as authoritative. So the point you're making here is, in a sense, the US is in a position because of dollar hegemony to say, this is our interpretation of, for example, sovereign immunity law, what money counts as being property for sovereign purposes, and what is, in the usual distinction,
Commercial asset.
yeah, Jure gestionis, like things that
Yes.
anyone could do. And that's an interpretation of the law. But if others tolerate your interpretation over a sufficiently long horizon, it becomes rather difficult to argue that it isn't the correct interpretation. So to bring everything back to the law of the sea, as I always do, it feels to me a little bit like the way custom was made by the US in the Continental Shelf Declaration, in that the Truman administration says we assert jurisdiction over over the resources in our continental shelf. If you disagree, let us know. And actually what happened was a lot of other states went, no, that sounds like a good idea. Now, I guess there's less sort of positive emulation in this case, but it's similar in the sense that quite often international rule formation doesn't arise either through formal treaty practice or through the slow accumulation of custom, but actually by essentially a first mover going, this is what we reckon the rule is, come at us if you've got a different view.
Yes. And sometimes states will protest some of these arguments, right? Just to clarify, states have not acquiesced, but sometimes they won't. And to move from state immunity to jurisdiction, the US has made a number of crazy arguments about its jurisdiction. For example, in the FIFA scandals, right? And here's the interesting thing. Switzerland extradited those people. And my argument in a realist key is this. If the US and Switzerland agree that the US jurisdiction is X, if we think of law as social phenomenon and not simply as like abstract rules, if it's the US and Switzerland, we kind of need to consider, at least in the context of banking, the rule is X, or the rule really looks like X for the purposes of like planning if you're a business, right? Or deciding what you will do if you're an economic actor, right? If Switzerland is acquiescing, even if not enthusiastically agreeing, to US assertions of jurisdiction having to do with the banking system, to me, in a world in which we think of law at the very least as partly as a social practice, if not only as a social practice, but at least partially as a social practice, we need to concede that for banking purposes, for like the purposes of like doing online transactions, we need to treat this as the law, even if we profoundly disagree. The other reason that very often US arguments of jurisdictions do not get challenged from private actors, which, for example, would give potentially even US courts the opportunity to say that they don't agree with a US department's assertions, is if you are a bank and you get hit by, let's say, a sanctions evasion claim, if you try to contest it in court instead of settling, you will be insolvent well before your case makes it through US courts, right? Because the sheer possibility of losing access to US dollars will make every single of your clients pick up their money and go, which means very often even US courts don't get to decide of some of these cases. Very often, these are assertions of jurisdiction by the US Department of Justice that are of doubtful legality, even under US law. But the social power of the dollar is such that private actors simply become extraordinarily risk averse, even if the council tells them, we will probably win this case. It doesn't matter. If you're a bank, you're not in the business of winning cases. You're in the business of offering like banking services for a fee, and no one will want your banking services. So very often these arguments go unchallenged and untested. And I would say they end up operating as law even when both their international, but weirdly, even their domestic US legality, if we think of legality as an abstract system of rules, is doubtful.
Okay, so that's just wild. But
It is.
let's try and concretize it a bit, because you've talked about some of the crazy assertions of jurisdiction, and we started with kind of the vignette about the FIFA scandal. But so what I'd like to do is sort of narrow down on what you think are sort of one or two of the most telling examples, or the most telling example under the heading of jurisdiction and under the heading of sovereign immunity, where the US interpretation, or at least, and this is an interesting distinction that you make that I'll come back to, the interpretations of certain government actors within the US, and your paper really does point out that there is not a single US supervillain approach to dollar hegemony. But what's the wildest thing you would like to point to under the heading of jurisdiction and under the heading of sovereign immunity that your paper looks at?
Yes. So sovereign immunity is perhaps less insane, but it's still idiosyncratic, right? So as you implied before, there is now a basically universal support for the idea that sovereigns are entitled to immunity, but not when they engage in commercial activities, right? When basically they're only entitled to sovereign jurisdiction when they're acting as sovereigns, when they do things that only sovereigns can do. And perhaps counterintuitive, that can mean engage in genocide, engage in torture, because these are things that only sovereigns can do. But they're not entitled to jurisdiction when it comes to commercial activities.
Sorry, not entitled to immunity.
Excuse me, yes, not entitled to immunity, of course. Not entitled to sovereign state immunity, which means you could potentially bring a claim against the sovereign in front of a foreign court, and you could even, under slightly more limited conditions, but enforce against them, right? Seize assets of that sovereign and, let's say, give compensation to someone, all right? So the distinction between sovereign acts and commercial acts sometimes will be clear, but actually very often it isn't. And when Argentina defaulted in the 1990s, there was a series of claims by foreign investors who had basically bought bonds by Argentina. They brought cases in front of US courts because, again, the bonds were payable in New York. That was the jurisdictional nexus there. And the case went all the way through all the way up to the Supreme Court, and the Supreme Court found that issuing sovereign debt is actually a commercial act, even if the issuing of debt and the issuing of particular bonds was done in a broader context of managing a country's public finance, right? Which I would think, in my silly little mind, that is a textbook case of a sovereign act, right?
Well, I'm just going to back up a bit here. So, like, yeah. So I was under the impression that the issuing of government bonds was something only governments could do, which sounds pretty sovereign. So I don't think you and I, Dina, could club together and issue called to the bar sovereign bonds, right?
No, but the problem with the US Supreme Court is that it said what you and I can do is issue bonds, any sort of bonds, issue debt, right? We can issue debt. If anyone wants to buy it is a different question. And we can enter contracts to sell this debt. And the US Supreme Court adopted a very peculiar understanding of what distinguishes a public from a commercial act or a sovereign from a commercial act, in which basically they said, once you do something with a contract, no matter, even the contract is about like buying nuclear bombs that you cannot do if you're not a sovereign, at least not legally. If you are doing things through private law instrument, that is a commercial act, and therefore your assets are not protected from sovereign state immunity, which gave us, you can imagine, the opportunity to hold out creditors to get their claims enforced against Argentina over creditors who had come to the negotiating table with Argentina. And, they had agreed that for every dollar they had spent, they would get but at least 30 cents, right? So the holdout creditors instead went into litigation. And because the US Supreme Court has such a peculiar understanding of what is a sovereign versus what is a commercial act, it basically it has contracted unbelievably.
Yeah, no, absolutely. So, I mean, it's been a while since I taught sovereign immunity in commercial transactions, but my sort of understanding from the old cases was, I think it was Trentex Trading Corporation, the 70s case out of the UK, was, okay, the case concerns purchasing concrete to build a military barracks. Now, only a government can have a military, but anyone can buy concrete. So this isn't really an edge case, right? It's a commercial transaction about concrete. But, you can understand that a lot of these things get a bit edge casey. But when it comes to, for example, a government procuring a battleship, yes, contract will be involved, a private law instrument will be involved, but I'm pretty confident that the acquisition of a battleship is a sovereign act, and I would expect it to be covered by sovereign immunity. What the US Supreme Court has said is, no, if you're using the law of contract at all, that is an quote unquote ordinary commercial transaction and acquires no immunity. So there's really nothing governments can do in a marketplace as a question of US law that isn't subject to the jurisdiction of US courts, potentially.
Yes. And especially not issue debt, right? And again, that is very important because it suddenly opened to US-based adjudication, because very often, again, these bonds are payable in New York, and they're payable in New York because they're denominated in US dollars. It suddenly opened up to adjudication, all basically debt negotiations, right? And it didn't, I would say, only strengthen the hand of holdout creditors. It strengthened the hand of all creditors.
Oh yeah, no. So I imagine that if the government of a developing or even a developed country suddenly needs to restructure its debt, that is, you're potentially telling me that that's going to play out in a New York courtroom, not as a sovereign negotiation with creditors.
Exactly. That's exactly right. Because there is always now in the background the possibility that any creditor could go to courts, and the US Supreme Court has opened the door to all the way going to enforcement, right? Getting basically let's say your reserve currency that you're keeping in New York for a rainy day in case your currency gets all floating. Now creditors can get their hands in it, right?
Wow.
So, and imagine they're not deciding a case here and case there. According to some counting, they're deciding more than 50% of sovereign immunity cases.
Okay, so that does suddenly become
Yes.
kind of Bond villainy. Like it does feel a bit like, we're back on the gold reserve and someone could just kind of go down into the vault and plunder national
Yes,
reserves of gold that are held in New York.
that's
Okay,
exactly right.
give me one of the crazier cases on jurisdiction, and then we'll move on
Right.
to why the US government isn't a unitary actor.
Right. Okay. So jurisdiction is such an interesting case, right? So sometimes we say, I transfer you money. And we imagine that somehow money leaves my bank account and goes somewhere, crosses the border. Nothing like that happens, right? What happens is your bank and my bank and any intermediary bank that we are using simply carry out booking operations, right? They move things in our respective accounts from debit to credit and from credit to debit. And your bank and my bank will probably have accounts with each other, and they go to that um, account as well, and they move things from debit to credit, right? That's what it means when we say moving money. Nothing is going anywhere. It is just booking operations. And according to the traditional doctrine of territorial jurisdiction, each booking operation, its legality, should be determined by the law of the state in which it takes place, right? So let's say I am in Australia, I'm transferring you money in China, um, and let's say our banks have bank accounts with each other, so I can do so directly. My transaction and the booking operation will be judged as legality based on Australian law. Your booking operation, the booking operation of your bank, will be judged as far as its legality goes based on the jurisdiction of Chinese law, right? Here is the problem if I'm transferring you dollars, US dollars, not Australian dollars. My Australian bank and your Chinese bank very often will not hold accounts with each other, which means they cannot clear the transaction, right? The transaction will not end up being, because at the end, we want everything to go back to zero as far as the banks are concerned. But they probably both hold a bank account with HSBC New York. Why do they hold a bank account with HSBC New York? Because they want access to US dollars. Which means at some point, HSBC New York will also carry out its own booking operation, right? The US has been saying the following: the moment there is any bookkeeping operation taking place under US jurisdiction, we have jurisdiction over the entirety of the transaction. And if my transaction with you was perfectly legal under Australian law and Chinese law, but it violated, let's say, US sanctions law, the US says we have jurisdiction over it, you're in trouble, and more importantly, HSBC New York is in trouble because it cleared the payment, right? Sometimes we would try to put even more distance between us and New York. We would clear the transaction, let's say, in Switzerland, right? So again, at the place where our transaction is perfectly lawful under domestic law, and then the Swiss bank would clear the transaction with the New York bank, but that would be nominally an entirely different transaction in which Douglas and I are not involved in any way. We are not part of this transaction. The US would claim that even in this way, which by the way is an extremely expensive and slow way of doing transactions, we have not circumvented US jurisdiction, right? They have a whole theory that says that even in this case, because the transaction corresponds to a transaction that would have been illegal if it had been cleared in New York, it is still illegal. In practice, Douglas, this means the following.
Wow.
The US has de facto claimed jurisdiction, not de jure, but it has de facto claimed jurisdiction over 99% of online transactions in US dollars. The only way that I can avoid for sure US jurisdiction in a transaction that has US dollars is frankly bring a suitcase of cash, and pay you. This is the only certain way to avoid US jurisdiction. And the problem, as I said before, is none of these arguments have been tested in US courts. These are arguments that the Department of Justice makes, but everyone gets so spooked that they will immediately sign deferred prosecution agreements with the Department of Justice. And not only they will comply, deferred prosecution agreements usually means a former Department of Justice employee is now your internal sanction compliance officer. And they are bringing whatever, yes, Douglas is making a face.
I really am.
Yes, and they are now bringing their legal arguments and the legal sensibility of the US Department of Justice becomes internalized by HSBC New York or whoever it is. And that's why I'm saying this is a form of lawmaking.
Right.
But perhaps formalism doesn't capture. Formalism would tell you, well, this argument is weird and it has never been tested in court. And if it had, probably it would be defeated even vis-a-vis US law. But my point is, does this matter? And for some effects and purposes, it does matter, but for some others, it doesn't, right? Because a legal consciousness and legal habits spread in which these wacky assertions of jurisdiction now become the private sector initially externally imposed, but gradually internalized legal consciousness, right? Because now you have a former, and it's also a great way for a former Department of Justice person to get an amazing job.
To get an amazing job in retirement. But it's kind of like a sort of lex mercatoria has been created, right? It sits outside the state. But just to really crystallize what you've just said, let's imagine the unthinkable hypothetical situation in which the United States had sanctioned an international court or tribunal, right? And let's imagine that its sanctions extended to providing any financial support.
What a crazy scenario.
I know. But any support by a private person to that international court or tribunal. And so imagine you wanted to buy a nicely printed copy of that court statute from its online bookshop. Even if that court was in, I don't know, The Hague, and you were sitting in Australia and you transacted with its online bookstore, and as far as you were concerned, its bank was in Europe, your bank was in Australia, but a shadow of the transaction cleared in New York, you would be personally liable, and possibly there would be accessorial liability for both banks. So as a consequence, they probably actually won't let you process the transaction.
That's exactly right. That is exactly right. That is what would have happened in that crazy scenario that we will never face. Yes.
Totally hypothetical. But so all of this sounds like
under sanctions, many of whom are terrible people, by the way.
Yeah.
Still, there is a question of why you would end up basically living out of a suitcase with cash, because no one dares touching an electronic transaction with you, right? And in 2026, especially if these are your everyday luxury item purchases, that's fine, but you cannot exist as an economic actor, at least an international economic actor in 2026 without being able to do electronic transactions, and especially electronic transactions with US dollars. So essentially, not explicitly, but essentially US jurisdiction, according to the US Department of Justice at least, has become almost coextensive with the electronic use of the dollar. And that is crazy. per my professional assessment.
Yeah, that being the technical term. Okay, so this sounds like, again, my Bond villain analogy, like, we've got this sort of single actor, the US government, that's doing all of this crazy stuff. But your paper cautions us against thinking that there's a single unitary US policy at play here. And in part, that's that all governments, once you start looking at them, are really more like a dysfunctional family, right? There's, sort of warring tribes and various configurations of power. But on top of that, there's the tension between it being an international and a domestic currency. So, an eye to time, could you explain quickly how those tensions play out and complicate this?
Absolutely. So, yes, one of the things I want to make clear is we treat often states as unitary actors in international law. This is a fiction. And it's a legal fiction that exists for a reason, but analytically can make us miss things, right? Which is, you say this, and I've really appreciated your wisdom, which is very often US state apparatus speaks international law not in order to bind itself towards other states, but in order to fight wars between different branches of government inside the United States. And like you first told me this, and that is so true. And it has helped me so much to think through things. So, for example, Congress and the executive tend to have different views of how far they should go when it comes to messing with foreign central banks assets, right? How far immunity does or doesn't cover them. And the reason for that, for example, is the executive will tend to have actually a more systemic outward facing view in which it says, oh guys, if we start going after other states' assets, they might also go after ours. Whereas very often Congress will be dealing with whatever domestic constituency and playing whatever domestic argument in which they want to appear the most patriots of all. Notably, Congress has been pushing in various occasions for the expropriation of the assets of the Central Bank of Afghanistan to give compensation to the families of victims who died during 9/11, right? The executive has been trying to stop this in every turn, right? And courts have been siding either way, so courts have been going back and forth in this struggle. But my broader point is this, and this is a good example actually to think through. Sometimes the US will use sanctions or will use, let's say more broadly, the privileges afforded by the primacy of the US dollar to do basically very serious and systematic stuff about the organization of a global political economy that they used at least to sit on top of. Right. So, for example, I would say allowing creditors to go after the assets of especially developed countries came in a very particular moment in which the US wanted to affirm its importance as the center of financial capital, right? And actually lower courts, before it went to the Supreme Court, said so explicitly. Weirdly enough, they said, well, we have to let them execute because New York is the center of global finance, and for it to stay the center of global finance, we need to be nice to creditors. The US Supreme Court said they don't care about this. They would never take something like that into account. But I would say they were, right? And I would say even the fact that they let them do this spoke to a very particular moment of taking the side or of US offering systemic support, not simply to capital or not simply to US businesses, but specifically to financial capital, right? Giving to financial capital an incredible legal power against especially developing states. So sometimes the US will use this power of the dollar to carry out basically, or used to do so because now they're giving up on that, to operate as a guarantor of the dominant economic system, right? Be like, this is not simply a capitalist system, this is a capitalist system that is predominated by finance, and we are going to use the power of the dollar to actually help finance, to help creditors. Sometimes, extremely often, they do the exact opposite, which is they use these privileges to run all sorts of like particularistic and nationalist and often just petty agendas against whoever the dominant party doesn't like at that moment, right? Like very often there will be no deep systematic logic behind what they're doing.
Right.
Simply,
So to quote one of my favorite
Senator
British,
Tedaki wants to grandstand.
yeah. So to quote one of my favorite British comedies, yes, Minister. You know, the art of diplomacy is about surviving for the next 2 centuries. The art of politics is about surviving until lunchtime on Wednesday, and those might put different priorities at the top of how you want to run the world financial system for your benefit.
Exactly. And we have seen, I would say we have seen the US, obviously, not just under Trump, but I would say the last 10 years, doing more and more of the latter, right? If not necessarily individual petty fights, but particularistic US national interests that don't conform, let's say, with financial capital, but very often they will cause problems for financial capital, right? Because banks had to pay incredible fines and they had to deal, as I was saying before, with these deferred prosecution agreements that force them to reorganize internally, right? You have to introduce new compliance department and you have to hire whoever a random person in the Department of not defense, sorry, of the Department of Justice is telling you to hire. So my point is that these two goals have been always in tension. And of course, it would be in tension when you have a global currency that is also a national currency. But I would say these tensions are becoming increasingly unmanageable. Obviously, the Trump presidency hasn't helped, but I would say the proliferation of sanctions precedes the Trump tendency. There is a broader issue here. And my broader point is that we can understand something both about the crisis of the dollar, but also about the crisis of international law if we understand this fundamental tension, which is about dollar hegemony, but it's also about something broader, right? It's about the fact that we have a global capitalist economy, but a global capitalist economy that is still mediated by domestic legal and political forms. And I think that tension can help us understand broader geopolitical tensions of our time, right? That this is a profoundly integrated capitalist economy, but things are still happening through the political and legal forms of states. So like if there is a broader thing, even for people who don't care about dollar hegemony, I think if you care about this particular moment of geopolitical and legal and economic tension and disintegration, the paper has something for you, even if you don't care one bit about money.
Right. So to sort of reformulate that in my terms, because I think it's a profoundly important point that we could spend another hour on, but we don't have another hour. But essentially, it's very common for commentators to look around at world disorder and go, oh, this is all about the crisis of neoliberalism. And we've had this sort of predominant view about how markets work and society should work around markets. And now that's not delivering for people and we don't know what comes next. So voila, crisis. But you're saying, well, actually going beyond that, we've got an internationalized form of global capitalism and global markets that's driven around the interests of finance because of the predominance of the US in that present global order, but then we've got the classic two-level game. For international law to work, it has to be mediated through national institutions, but those are also not working, or indeed, in the US case, they're feeding this unpredictability from the national level up into the international level, which is then being globalized through the financial system that the US dominates. Have I got that roughly right?
Perfect. I could not have put it better, actually. Thank you. I appreciate it.
Okay, well, I've definitely learned something. What I've learned frightens me profoundly, but that's a separate question and not totally unusual for this podcast. So, look, that's a lot to think about, and it's quite frightening, and the world is a lot to think about and quite frightening. So I'll go to one of our traditional wrapping up questions about escape routes. So to the extent that you can take your eyes off what's happening in the world at the moment, Dina, what are you reading, listening to, or watching or doing when you need a break from it all?
Yeah, I mean, it will hardly be light entertainment, but I'm so happy that House of Dragon is back. I wait for every Monday evening to see what new crimes, war crimes I'm about to defend.
Right.
Yes, so I love it. I'm so happy that it is back. I watch it religiously every Monday. Yeah, so that is my thing. I'm always a TV watcher. The second is keeping it as vague as I can. Um, Both me and my partner are only children who live overseas, and it's for the first time due to a friend that there is tiny babies in our lives. Not our babies, just to clarify, not our babies, and it is a joy and it's so beautiful. And I don't want my own babies, but those babies, I love being an aunt.
Oh yeah. No,
I love being an
little kids are amazing. And yes, I am definitely the kind of. I think you've occasionally described me as having jolly dad energy. I'm now sort of trying to claim it as big dad energy, and I just love being at an age where, with kind of grey hair and a beard, I can lean over and coo at strangers' babies, and no one thinks it's weird.
Yes, yes. No, it's beautiful. I never thought I would be interested in babies at all, and I still don't think I can take care of them 24/7 for 18 years. But having them a little bit, having them in your life, because of my very particular life circumstances, I didn't have nieces and nephews
Yep.
by blood, but now I have nieces and nephews by choice, and it's beautiful.
Oh, that's wonderful. Okay, Dina, thank you so much for that. Let's leave it there. Thank you for joining us, everyone, and you'll hear us next time. Okay, bye-bye.